Hello, YouTube. I'm Vince White. I'm an employment attorney, and today we're answering a question from a YouTube user, Pamaroon. Hope I'm getting the name right. And she responded to a recent video we did about an individual who was sexually harassed, and the sexual harasser was just sent to classes. And her question was, what determines whether counsel takes a sexual harassment civil matter, so I assume here sexual harassment or workplace discrimination, either or, interchangeable for the purposes of this question, whether counsel takes a sexual harassment or discrimination civil matter to state or federal court, and why does this choice exist? Okay, so we'll answer the second question first. Why does this choice exist? There is a tension between the federal government and its powers and the powers given to the state governments. There's always been a tension. Over time, the federal government has gained a great deal more power, but you may remember in school, you were probably taught about checks and balances. You know, the judicial branch offsets the executive, and there's the legislative, and the tension between them keeps any one of them from gaining too much power and maintains some increment of our freedoms, right? Well, this works to an extent, but the other tension, the other kind of checks and balances in place there, are that the states have certain powers and the federal government has certain powers, and they don't always agree about who has what powers. So that is the quick answer as to why you have this choice between state court and federal court. Now, the answer to your question, why counsel might choose to take a sexual harassment case or a workplace discrimination case to state or federal court, is going to depend on the jurisdiction. So I'm going to use the example here of New York. And there's a lot of things to think about. So right off the bat, let's knock out state court and federal court are not the only two options. You have agencies you can file with. You have arbitration. Both the agencies that handle discrimination cases and sexual harassment cases in the workplace and arbitration offers potentially a more efficient process and a more private process. So there are certainly people who would want to avail themselves of those two options. But if you've come to the conclusion that you want your case to be public, and as public as possible, right? An agency case, is it perfectly private? No. You can't be. There's human beings involved. It's never going to be perfectly private. You basically can't trust government employees very far. If you have an exciting case, they're going to talk about it. There's all these ways. Things happen, right? It's not perfect. But the agency cases in arbitration are far, far quieter than what you might file in a public docket for a state court or for federal court. So if you determined you're okay with the public docket, and realistically, if you're going to state court or federal court, you probably want a jury. You probably want to have your case decided by a jury, right? And listen, juries are valuable because they're not really jaded the way an administrative law judge in this field might be, right? How many sexual harassment cases does an administrative law judge, ALJ, in this field see a week? 10, 15, 20, 500? I don't actually know. And the problem with that is they start to see so many that they become jaded, and they start to think of, okay, I've seen a bunch like this. Generally, I give 30 grand for a case like this, so 30 grand go away. Well, that could be the right result. It's possible. But that's not, certainly we're hoping for more for a case of sexual harassment, right? That's not an exciting outcome. Jurors tend to say, oh my God, and this is if they believe you, right? If the jurors are siding with you, they believe your version of events, they're going to say, oh my God, this was horrible. I can't believe you had to go through this. I want to make this right. And I'm going to assign as much money as I think I legally can to try to make this right. That is often the case, right? Juries are very unpredictable, but that is often the case that juries will assign larger amounts in terms of damages and awards on a case than an administrative law judge might. So That's why people often choose to go to litigation. They're okay with their case being public, and they're trying to swing big. They want as much potential to win at trial as possible. Then you have the choice between the state courts and the federal courts. In New York, the federal courts tend to see more discrimination cases. And remember, when you're bringing a discrimination case or a sexual harassment case in federal court, especially in New York, you're generally not leaving behind the state claims and the city law claims if you're in New York City, or even the local claims, depending on what county you're in, right? Generally, you get to plead all of them. At least that's the goal. So that's an advantage. Now, you might file in federal court because the lodestar provisions, and that's an old word, they have a new word for it now, but essentially the fee application process is easier in federal court. If your attorney wins your case at trial in this field, right, workplace discrimination, workplace sexual harassment, there's a good chance they can put in to have the other side pay their fees. And often the chance that the fees will be paid to your attorney and the chance that the fees paid to your attorney will be significant are higher, much more likely in federal court. That's important because certainly I don't know about every firm, but I know our firm, if we're paid by the other side, we have our percentage on a case, but the other side pays us twice our percentage, then we're generally going to go to our client and say, hey, you don't owe us anything. Other side paid. Yay. Great. We don't have to take from you. We can do the Robin Hood thing and take from the bad guys. And we hope that we helped you, right? I think most firms do that. I don't know. I can think of one firm that I know that I can recall trying to take the fee application money and their percentage and money up front. There's some bad firms in the world, right? Now, state court, it's easier, it's slower, takes longer, but in New York, the standards are a little bit looser, right? It's easier to win a New York State human rights law claim for workplace discrimination than it might be on the federal level to win. Some of the standards are a little bit looser, a little bit more forgiving, especially the standards as tied to retaliation. So here you're doing this balancing of, okay, I can bring all the claims in federal court, or if I go to state court, maybe it's easier to win. And also, it's worth noting that the statute of limitations on federal claims is incredibly tight. Depending on the state you're in, it's either 180 days or 300 days. That's insane. That's insane. That's not how human beings work. Human beings who have been sexually assaulted take time to process that before they can go forward with a claim. That is, in fact, well documented. So the federal government statute of limitations is kind of abhorrent. It's a little bit evil, which kind of is in keeping with the concept that maybe the people who made those laws weren't super excited about helping you, right? Maybe they wanted, for political reasons, to be seen to be doing things, but they wanted to also make sure those things weren't too great for you, right? So that's an issue, right? If you have a case that the last act of serious discrimination, the last act of sexual harassment is 310 days ago, well, that case is probably getting filed in state court here in New York State. So it is different jurisdiction to jurisdiction. Each jurisdiction has its own laws. You need to look at those laws. You need to look at the procedures of the federal court in that area and kind of make a plan. It is a totality of the circumstances kind of plan. It's tactical. Also, frankly, sometimes employment defense firms in certain areas aren't really up to speed on federal court, so they're not comfortable and you can smack them around a little bit. I've heard that sometimes trial teams for federal court can cost a lot more on the defense side than trial teams for state court. I don't know if I buy that, but that has been maintained to me by many, many plaintiffs and defense attorneys for years. I don't really see why that would be true. It takes half a day to be admitted to federal court. And I would think anybody in this field would have federal court experience. But listen, I can just tell you what people tell me. So my kind of scattershot, all over the place answer to your question, Pamaroon. I did try to make this video yesterday. I recorded for about 8 minutes, a couple of takes. And then on the 8th minute of my video, the hard drive I was using filled up and my video stopped and I couldn't finish. And I was sad because all my work was wasted. But let me know if this answers your question. If it does, if this was helpful, consider liking and subscribing. That does help me to help more people just like you. And yeah, I'll check the comments on the videos to see if I can answer more questions for folks. Take care, everyone.